So perhaps we should start off by explaining, well, what is a secondary victim?
You just have to say that's the rule. It's not that I agree with it, it's just the rule.
So if someone has lost a loved one to negligence, what can they claim?
Fathers find it really difficult to feel that they're pushed out and that their pain is not recognised in the same way.
Members of the public would be surprised, really, at how little is awarded for the death of an individual. Hello, and welcome to today's episode of Medical Negligence Matters. Today we're going to be talking about secondary victims, try to explain a little bit about what a secondary victim is and how claims involving secondary victims differ from others. And with me today to talk about that is Tami Frankel. Hello, Tami.
Hi.
So perhaps we should start off by explaining, well, what is a secondary victim? Well, of course, a primary victim is somebody who is directly injured by the negligence of somebody else. Whereas a secondary victim is somebody who suffers a psychological injury as a result of witnessing the injury to a loved one. And perhaps we could start with a bit of explanation about what one has to, or what historically one had to establish in order to prove a claim as a secondary victim.
Yeah, well, originally, because of course now the door has largely been closed to claims for secondary victims in medical negligence cases, but originally, broadly speaking, somebody had to show that they had witnessed something so shocking that it had caused them a psychiatric injury, and that the shocking event they had witnessed was either a serious injury to or death of a close relative.
That's right. They had to prove that they had a sufficient tie of love and affection, I think, as the judges would put it. But they had to just show a sufficiently close relationship with the individual who was injured. And they also had to show that they had suffered, as you say, a significant psychiatric injury. And I think the case law goes back very many years, doesn't it? And I think one significant moment, I suppose, in the evolution of the law on secondary victims was the case of Alcock, which related to the Hillsborough disaster.
Yes.
And in that case, the House of Lords was looking at, where one could draw the line in allowing individuals to bring claims for psychological injuries, for witnessing injuries to others. And of course, in that horrendous case, the claimants were those who had not been present in the stadium during the disaster at Hillsborough, but had been watching the TV coverage as it unfolded, and suffered as a consequence of watching that. And of course, what the House of Lords said there was that watching an accident unfold in that way on television was not sufficiently proximate to give rise to a claim. And I think in the years that followed that, courts came to some very different decisions, didn't they, about...
Yeah. Well, they'd set down some sort of tests, some hurdles to jump in order to be successful in a claim as a secondary victim. I mean, it was called nervous shock, which sounds very archaic. But to succeed in a claim, they'd set out these tests these hurdles you had to jump over. And there was a level of subjectivity in all of them, which allowed different courts to reach different decisions, especially as you tried to apply those rules to very different situations.
I think this was the problem, wasn't it? I think that courts and judges were struggling to fit very different individual circumstances and some very traumatic and upsetting situations into quite a rigid framework. And I think it's true to say, isn't it, that when one looks back at the decisions that were made over the years, there is a certain inconsistency.
Yes.
And I think some people would say, well, why did that person succeed in their claim, whereas this person didn't? And yet, seemingly, the events were...
better position according to the rules.
Just as traumatic a situation. So I think that there was a general recognition amongst lawyers that the situation wasn't entirely satisfactory.
Yeah.
And of course, medical negligence was always slightly different from personal injury because, of course, in accident cases, it was, firstly, I suppose, easier to identify an accident, so to speak, wasn't it?
Yes,
an event. Whereas in medical cases, that was much more tricky because it was unusual, for example, for a loved one to witness a medical accident, not being present in a operating theatre, for example.
And often the things were more to do with something that wasn't done or was done incorrectly or a failure somewhere.
Exactly, sort of omissions in treatment rather than
witness
actual
that
physical acts. And I think that things changed dramatically, certainly in the medical negligence field in January 2024, when the Supreme Court issued their ruling in the case of Paul and the Wolverhampton NHS Trust. And this was a terribly sad case about two young girls who witnessed the collapse and death of their father from a heart attack, which was found to have arisen because of a failure by a hospital some 14 months earlier to diagnose and treat his heart condition. And I think it's true to say, isn't it, that the court in looking at this case, which it dealt with two other quite similarly tragic cases, was looking perhaps at making a public policy decision about
drawing
secondary
the lines.
victim claims, rather than possibly what somebody in the street might regard as justice. So I think there was undoubtedly a policy element, a background to the decision.
Yeah, I never really understood that because often those decisions, policy decisions, are made to close the floodgates to stop a huge, overwhelming number of claims from a certain source or of a certain type. But there never really were that many claims by secondary victims. And the rules that already existed limited who could claim, in what circumstances they could claim, and how they had to prove their claim. So I never really understood that, and I've always thought it's really unfair.
Yes, I mean, one might say that it was sort of trying to deal with an evil that didn't really exist.
Doesn't exist, no.
Because certainly in my experience, these cases, as you say, were not terribly numerous.
No.
And I think that the effect of the decision has been quite harsh in medical negligence because, as you say, it has effectively closed the door for the vast majority of secondary victim claims in medical negligence.
The three cases themselves were instances that most people would be surprised someone can't claim in. Two daughters witnessing their father have a heart attack and die in front of them in the street. Nobody would be surprised if you suffered a psychiatric injury as a result of that. You can see it won't happen all the time. It doesn't make sense, and it is unfair.
Yes. I think that the judgment of the Supreme Court is lengthy and very technical, but I think some of the key points, certainly the first thing that they were looking at was one of the issues of, well, what constitutes an accident? Yeah. And I think this is where medical negligence and personal injury is dealt with very differently because, as I say, a personal injury and somebody being run over in the street, obviously a single shocking event, accident. In medical negligence, as you say, very often it is not a single event. It might be a series of events of things being omitted or things being done or decisions being made, most of which are not witnessed by family members.
Yeah. Of course.
And sometimes not even by the patient themselves. So trying to establish an accident in medical negligence is what could legally constitute an accident to satisfy the test is I think, very, very difficult. But I think the other very important point was the idea of where a doctor's duty lies. And I think this is the thing which is fatal for most medical negligence secondary victim claimants, is the court found by a majority that a doctor's duty of care does not extend beyond the patient.
Yeah, it does make you think, why are doctors different in that respect to anyone else who owes a duty of care to anyone.
I think that is obviously a policy decision, isn't it?
Yeah.
I mean, I suppose sort of rolling back from a legal point of view, in any case in the UK, in order to establish a claim for negligence, you have to show that the person who committed the act of negligence owed a duty to you as an individual. And I think this is where...
Or as a class of
or
people.
as a class of individuals. And so the Supreme Court has ruled that family members of patients are not within that group of people to whom a treating doctor owes a duty.
It doesn't seem fair because, of course, the car accident that you're talking about, if that was caused, say, by brake failure due to some omission by a mechanic, the same wouldn't apply.
Yes, I think that the playing field is not entirely level now between sort of road traffic accident, for example, victims and medical negligence victims, which is very tricky. I mean, I think many legal experts will sort of say, well, technically speaking, the door isn't entirely closed, and there may be cases that can be brought in the medical negligence field for secondary victims. I'm personally not aware of any having been decided recently since the Supreme Court's judgment. But it may be that lawyers thinking analytically around the new definitions that have been laid down may be able to bring claims, but it's undoubtedly much more difficult.
It's going to be more difficult and very fact-specific on...
Thinking a little bit about the sorts of cases that involved secondary victim claims in the clinical negligence field. I mean, in my experience, quite a significant number were related to childbirth.
Yeah. And it seems now particularly unfair because you could have a situation where a father, for instance, is present at the delivery is mismanaged, which leads to the death of the child, which does happen. The mother has a claim because she also has a claim for the physical injury. So the mother has a claim for the psychological injury she suffers as a result of witnessing that.
As a primary victim.
Yep.
Yeah.
And the father, who was standing right there, is as involved, is exactly the same relationship to the baby, does not have a claim. It just doesn't make sense.
It's a very difficult concept, I think,
and you have
for
to explain
injured
it
families
to
understand.
Yeah. Fathers find it really difficult to feel that they're pushed out and that their pain is not recognised in the same way.
It's very hard indeed, isn't it? So if someone has lost a loved one to negligence, what can they claim? Well, of course, in fatal claims, there are statutory awards for bereavement for certain categories of claimants, aren't there?
Yes. So, well, of course, that again is unfair because if the baby is stillborn, because the categories include children, but not, it's very limited categories who can claim, and the bereavement award is a statutory award, which isn't very much. I think, is it 15,980
something like that now? It
at the moment.
Is increased from time to time, but not.
But it's difficult to tell a parent that's what the child was worth. But of course, it's even more difficult to tell the parent of a 19-year-old who wasn't married and didn't have any children. There's no bereavement award. All we'd be able to recover is if somebody was relying on that 19-year-old for either financial support or some sort of services they provided. And generally with 19-year-olds, that's not the case.
Yes, I mean, I think claims for compensation in fatal cases can be quite difficult. And the compensation, I think members of the public would be surprised really at how little is awarded for the death of an individual in this country. Of course, as you've sort of hinted and touched on already, the financial losses arising from someone's death can be claimed.
Yes.
But as we've been explaining earlier, I think that the psychological impact is not necessarily recognised in the way that many people would expect it to be, and that's hard.
One of the things that means you can't recover for is if, I don't know, the spouse, children have had some sort of therapy to deal with the death. They can't recover the cost of that. And sometimes that's really difficult to explain to people. You just have to say that's the rule. It's not that I agree with it. It's just the rule.
Yes, the law doesn't always provide what people expect it to, and that's that can be difficult. But it's the job of a specialist lawyer to explain to claimants,
and not to give false expectation. Yes,
exactly, and to help people to sort of understand what they can and cannot claim for, and perhaps to understand the rationale behind it, which
I don't understand myself in this case. To explain what the decision is based on. Yes, no, absolutely.
It's a very complex and emotive area, and thanks very much, Tami, for helping us to go through some of those difficult questions.
Thank you.